Good morning. I'm Don Wallace. I'm the chairman of the International Law Institute, and I'm very happy to welcome you to this webinar on investment disputes and COVID. Welcome, and turn the webinar over to my colleague Borzu Sabahi, who will moderate the webinar. Borzu.
Thank you very much, Professor Wallace. Welcome everyone to the International Law Institute's 60-minute webinar on investment disputes and the COVID-19 crisis, the view ahead. I'm co-director of the ILI's Investment Law Center and a partner at the law firm of Curtis Malley Prevost Colton Monster LLP in Washington. Today we have a very distinguished panel of speakers to discuss this topic from various angles. Let me start by Christina Behari from Foley Wag LLP. Christina has a wealth of experience representing states in ISTS and public international law disputes. Prior to that, she worked for the Canadian government on ISTS and other matters. She is well known for her knowledge of law of damages and has a recent book on the topic published by Brill. Christina has been recognized as a future leader by Who is Who Legal. Second, we have Ian Laird. He's a partner and co-chair of the Crowell and Mooring International Dispute Resolution Group in Washington, D.C. He has over 20 years of experience as counsel and arbitrator in international investment disputes. He is a co-director of the International Investment Law Center, together with me, an adjunct professor at Georgetown University Law Center, a founder and former editor-in-chief of Oxford University Press's Investment Claims, and editor and author of numerous books and articles. Third, we have Jennifer McCandless. She's a partner in the Washington, D.C. office of Sidley Austin. Jennifer has almost 20 years of experience litigating investor estate and commercial arbitrations. She has represented both investors and estates in a variety of industries, including oil and gas, energy, electricity, mining, financial services, real estate, insurance, and infrastructure. She has also represented parties in disputes before the WTO. Fourth, we have Dr. Jose Antonio Rivas. He's the founder of Expropriation LLP, a boutique international arbitration law firm. He has a vast and diverse experience working on ISTS cases in major law firms, negotiating investment treaties for the Colombian government, and working as a third-party funder. He's an adjunct professor at Georgetown Law School. Fifth, we have Mallory Silberman. She's a DC-based partner at Arnold & Porter and has more than a decade of experience litigating investor estate arbitrations. She has been counsel in more than 35 ISTS cases, representing not only investors, but also 7% of the world's countries. In addition to her work at the firm, Mallory is also an adjunct professor at Georgetown Law Center, where she has taught since 2012. Before going to our panelists, I would like to quickly first make a declaration on behalf of the group that the views expressed here are only those of the speakers and cannot be attributed to their law firms or clients. And second, I want to quickly set the stage by providing an overview of the crisis. During the last 15-20 years, we have seen a variety of crises around the world. The Argentine financial crisis, the 2008 recession, the Arab Springs, all of these spawned a number of arbitration disputes. In a sense, major crises are not rare. What makes the current crisis unique, however, is that it relates to public health combined with an economic crisis. World Health Organization, as you know, has declared the coronavirus crisis as a global pandemic, quote unquote. Governments around the world have adopted a variety of measures to control the crisis. And I think that would be useful for context for me to just enumerate some of them. You probably are familiar with orders to close non-essential businesses and lockdowns. A number of retail businesses have experienced difficulties. J.Crew has filed for bankruptcy, and other kind of companies have done that. Restaurants have had to close down. I read that Le Pain Quotidien has filed for bankruptcy. We have car rentals in problem. Hertz company has filed for bankruptcy. You all have heard sports events being canceled or postponed. The most important is probably Olympics. Summer Olympic 2020 has been deferred to next year. The governments have introduced a number of bailout packages. You all probably are familiar with Paycheck Protection Program of the United States government distributing $350 billion in funds. And there are other issues like travel bans, which have affected airline industry. Avianca Airlines have filed for bankruptcy. We have major manufacturer of airplanes experiencing problems. I read that Boeing has been allocated $17 billion in aid by Senate. You probably also followed the oil prices dropping to rock bottom in April, which has affected a number of drilling operation and other businesses. Other countries in Mexico, Peru, elsewhere, everywhere we see various measures to control the crisis. For example, a global arbitration review reported that some renewable projects have been halted in Mexico, and there have been a ventilator manufacturer which was exporting its product. It has been ordered to stop its operation and cooperate with the Mexican authorities. And there has been toll road fees have been waived. That was in Peru. So there are a lot of events, and our panelists may introduce more of these events in their discussions. Implications of these measures are being discussed all around the world right now. There are a variety of conferences, etc., and a variety of views. I read the other day that the Columbia Center on Sustainable Development had a newsletter which was calling for a moratorium on ISTS during the pandemic. There were a number of protests against that, and there are other people who are focusing on whether the measures can be a basis for bringing claims by foreign investors or not. Our panel today will touch upon some of these issues, and we have a limited time, so I go directly to Ian Laird, and who's going to be our first speaker, and I ask Ian to cover some of the claims that are likely to arise from the above measures, particularly fair and equitable treatment, national treatment claims. Ian, would you please?
Well, thanks very much, Borzu. It's a real pleasure to be here today and invited by the International Law Institute to talk about this very important topic. So thank you to the ILI for organizing this webinar, and thank you to Borzu for moderating the session. And I have to say, it's a real honor to be on a panel kicked off by Professor Wallace and my fellow panelists, who I think their introductions are very modest. They're incredibly experienced in this area, and I'm looking forward to hearing their comments as we go along. So I have a brief few minutes to cover a topic which a bunch of us teach these topics in law school, and we'd actually spend whole classes on individual topics that we're going to address today, and whole courses on some of the broader issues that we're dealing with. So I've been tasked with dealing with the general topic of standards of protection. And these are the typical obligations set out in the some 3,000 odd bilateral investment treaties and free trade agreements that have been signed between almost all countries in the world. And these set up obligations that can generally be enforced through dispute resolution mechanisms, through generally international arbitration mechanisms, through the World Bank rules of ICSID or the UNCITRAL rules of the UN Commission on International Trade Law. And as set out in the slide, there are, I guess, three basic flavors of protection: fair and equitable treatment, full protection and security, and the non-discrimination standards of national treatment and most favored nation treatment. The fair and equitable treatment standard is the one that you see the most frequently in ISDS cases. It's the claim most frequently brought by investors, and the one that tribunals routinely make their decisions on. The other standard or the other protection, so to speak, with regard to expropriation and compensation for expropriation, which we'll be discussing in a moment, is the other one that is addressed in great part by tribunals. Now, fair and equitable treatment is, as it suggests, a very kind of basic standard assuring a proper level of, I guess, justice and fairness, but underlying it are some basic prohibitions which are very relevant in this time, this unprecedented time when governments and officials in governments and politicians are making some of the most difficult decisions of their lives about how to respond to the crisis, how to deal with the health issues, how to deal with the economic impact. It's clearly a very difficult time to make those types of policy decisions and put them into effect. And having worked in government myself, I'm certainly very sensitive to the difficulties of making these types of decisions. But unfortunately, there is sometimes a temptation in the crises and the examples that Dr. Sabahi gave earlier. There is this temptation by some officials in government to treat locals, for example, better than foreigners in some manner, to act in a way that is not entirely consistent with the law, or and this is part of the fair and equitable treatment standard, to act inconsistently with the what's called legitimate expectations of an investor when they make a foreign investor when they make an investment in a foreign country. So fair and equitable treatment basically covers those kind of economic decisions and regulations in government, and make sure that they're not applied in an arbitrary and discriminatory fashion, and that when an investor makes an investment, that their expectations in terms of the rule of law being followed are met most broadly. Another standard, full protection and security, is one that is not frequently applied by tribunals, but the most frequent case you see it is when there is a failure by a government to provide the kind of physical protection and legal security that one would expect from a government. And when we see the kind of protester and mob violence destroying property, that's actually the kind of example that has come up in the case law, and that if there is wide destruction and governments fail to protect foreign investors, that could potentially lead to potential claims. The other standard, which is on the slide, relates to discrimination, or the non-discrimination standards. And national treatment really applies when there's a comparison of a foreign investor with local investors and their investments, and that there is some differential or different treatment being applied as between them, that in a sense the local investor receives some sort of better or best treatment that the very similar or like foreigner does not receive. And as you can imagine, there is this temptation to provide benefits, and sometimes these are the economic benefits that we've been seeing, either given by the US government or many other governments, which local companies and investors who are acting in pretty much the same circumstances are not given the ability to have certain benefits, economic benefits. One example of a case, and I wanted to provide a practical example of a situation in which this was an environmental case called the S.T. Myers case involving the Government of Canada, and this is a 20-year-old case that I worked on. And in that case, that was a case that involved what was a fairly open discrimination against a US investor in Canada with regard to certain environmental measures. And in that case, there was openly an element in which the Canadian competitor of the Myers company was being favored. And that was clothed to some extent in justifications of environmental protection, which did not turn out to be correct in that case. It was an economic and discriminatory measure. And that kind of open discrimination is a risk. So to finish off my time, and I see that we're moving ahead in the schedule, on the basic look ahead, and I know we're trying to be some forward looking in this panel. Dr. Sabahi mentioned that some commentators have proposed that we need some form of international economic martial law in which ISDS arbitration and the types of standards and protections provided by these types of provisions, that this be suspended during the economic crisis. And I think it's fairly clear that the opposite view should take place, that this is in fact the time when rule of law and rules should be adhered to, and that governments and investors should in fact be working together. I think that times will be challenging over the next year and next 2 years to restart economies and to build infrastructure and businesses and get the economy going. And it is not the time, I would say, looking ahead, to be restricting the economy. So I'll leave it there for now, and I look forward to hearing from the other panelists.
Thank you, Ian. To keep on the schedule, I'm gonna go keep going to the next speaker, because if there is time, we will have some follow-up questions. Jennifer, you're next in line. Would you please give us some overview of interaction of these measures with expropriation standards, umbrella clauses standards, whether the measure can be a basis of a claim, what are the potential defenses there to those claims, and thank you.
Sure, thank you, Borzu, and also thank you for ILI for putting on this very important webinar on this very timely topic. As we know, as Borzu mentioned at the beginning of the presentation, there are a number of measures that have been taken that have potential to have an adverse effect on businesses and foreign investment around the world. And there are lockdowns that are happening, prohibitions against flights, and that's obviously having an impact on businesses. So what does that mean from an investor-state perspective, and what does that mean for investors? What does it mean for states? And how can states act to limit their liability in a potential investor-state case? And as Borzu mentioned, I'm going to address the issue of expropriation and then also umbrella clauses. So first, with respect to expropriation, just to kind of lay some of the groundwork, expropriation is basically the taking of property, a government taking of a property right. That right can be something that's tangible, like property, like real property, real estate, or it can be something that's intangible, like contract rights or shareholder rights. And governments under international law are permitted to expropriate, as a matter of fact, property. It's just it has to do it under certain circumstances, and those circumstances are, and then they will vary depending upon the language of a treaty or relevant provision of a free trade agreement. But essentially, it needs to be on a non-discriminatory basis for a public purpose and with prompt, adequate, and effective compensation. So a government can take a measure that will have the effect of, or will actually take a property if the actions are done in the context, in the way in which I was just describing with those limitations. Now, expropriation can either be in the form of direct expropriation, which is the actual taking of property or taking of a title. That is kind of a more traditional old situation that has occurred, often occurred like in the 1960s, for example. Military surrounds a plant and takes over the plant and kicks the foreign investor out and doesn't pay them any compensation. Indirect expropriation is a situation in which government measures occur that have the effect of a taking, but they don't actually necessarily take title to the property. But the actions or the measures of the government have the effect of taking. The key is that it has a substantial deprivation of value of the foreign investor's investment. And it's, of course, in this context that COVID-19 measures are likely to fall, because they're not likely going to be surrounding a property and physically taking over that property on this basis. It's more likely to be a measure that's an indirect expropriation, where a government has taken a measure has the effect of depriving the value of a foreign investor's investment. So it's in that context that then a measure may be run afoul of an international law commitment by a government. Some treaties and free trade agreements define or go further to provide more information about what constitutes or doesn't constitute indirect expropriation. And I'm going to give you an example of something from the US Model Bilateral Investment Treaty, which is used by the US government in some of the negotiations for creating free trade agreements in particular, or bilateral investment treaties, and is included, this type of language is included in some of those treaties and in others. So a further definition with respect to what does or does not constitute indirect expropriation. In the US Model Bilateral Investment Treaty, it states, quote, except in rare circumstances, non-discriminatory regulatory actions by a party that are designed and applied to protect legitimate public welfare objectives, such as public health, safety, and the environment, do not constitute indirect expropriation. So if a treaty or a free trade agreement includes this type of language, then there's more leeway for a government to take action so long as it fits within those parameters that are stated. So to steer clear of potential liability, it's important for a government to act, to make sure that any of the actions and the measures that are taken are in fact reasonably tied to public health concerns. Obviously, actions actually taken to protect welfare of humans in this context, it could easily fall within the definition of a public health situation. And what governments need to make sure they do, or where they need to, in order to keep consistent with those obligations, is to make sure that any measure is reasonably tied to public health and not going beyond that. Also, to make sure that those actions are applied on a non-discriminatory basis. So for example, a government should not require a business to close if there's absolutely zero possibility that the actions of that company could be health related. I'm thinking of, say, an automatic a plant that's assembly plant that has everything automated, and there are like no humans involved, or maybe the humans are remotely involved. I mean, that wouldn't necessarily be closing of that plant may not be reasonable in the context of concerns for public health. Or making sure that if there are similarly situated businesses and they have similarly situated risk factors for of public health concerns with respect to COVID-19, that the governments take actions or measures that are equally applied to both, as opposed to preferring one and closing down one business or type of business and not closing down another business or type of business, even though there's no real distinguishing factor between them or the public health risk that's at issue there. So there's certainly actions, that governments can take to make sure that they fall more in line with the obligations under international law that they have. The second area I wanted to address is with respect to umbrella clauses. And just to give you a general recollection, to recall what it is for those who know and for those who don't, to give you a short understanding of what they are. And these are not included in every FTA or in every bilateral investment treaty, but they are included in some. And they require that governments honor their commitments to investors, including in contracts. And the idea is to preclude governments from abusing their sovereign power to invalidate their contractual obligations. So contractual breaches by governments can lead or may lead to a claim under a treaty that has that type of protection. It's also true that if a treaty does not have that type of protection through the most favored nation provision, it may be possible to reach out and borrow it from a different treaty and bring that into a treaty that doesn't otherwise have a protection. So government should be careful in that context as well, and respect their commitments that they've made to foreign investors, in particular their contractual commitments. Now, it may be that there are force majeure provisions that are included in contracts that will provide for certain exceptions, that actions that can be taken that don't run afoul of the contract in the basis, because it falls within, a measure might fall within force majeure. One would just have to be, governments should take a look and make sure that any action falls within that context, depending on the definition of force majeure in that context. So in conclusion, whether an investor's claim would be valid or not, or whether a government measure runs afoul of international obligations will of course depend upon the facts of the case, as is always the case, and also upon the language in a particular treaty or in particular free trade agreement. And I think that's all I have.
Thank you, Jennifer, for that concise and informative introduction to this topic. Let's now move to Jose Antonio. We heard a little bit about claims limitations, what type of claims that can be brought. Jose Antonio, would you tell us what sort of defenses are available to governments in this situation? Defenses on the public international law, maybe there are exceptions in the treaties. If you could outline those for us. Thank you very much.
Thank you, Borzu. And before I answer your question, I'd like to thank Professor Wallace and the ILI and the co-organizers, Borzu and Ian Laird. As to the justifications that a state may take, when a state takes certain measures to address a health and economic crisis created by COVID-19, it may attempt to justify those measures in various ways. I will only refer to two specific justifications. One, as necessary measures to protect legitimate public purposes, such as the protection of health or essential security, or two, as measures that were taken to protect an essential interest of the state in the midst of a state of necessity. So let's consider these two justifications. Necessary measures to protect essential security interests or to protect human lives, as recognized in certain treaties, constitute a different category from the customary state of necessity provided in Article 25 of the International Law Commission articles on state responsibility. This is in line with a number of cases in investment treaty arbitration. Now, the necessary measures exceptions must be provided by the treaty or in the treaty. The language of the treaty will determine how and if the exception applies. Two examples of those are, for instance, the Article 11 of the US-Argentina Bilateral Investment Treaty, where the treaty specifies that this treaty shall not preclude the application by either party of measures necessary for the protection of its own essential security interest. There's a question of whether or not this justification is self-judging or not. And now let's look into another specific exception, which is the exception provided under the CTA, which reads that as long as the measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between the parties, where like conditions prevail, or a disguised restriction on trade in services. And here comes the important part: nothing in this agreement shall be construed to prevent the adoption or enforcement of measures necessary to protect human, animal, or plant life or health. Now, clearly a tribunal will look as to whether these measures were necessary. Now, depending on the language of the treaty and on whether the requirements included therein are met, a tribunal may rule that an exception applies and that the state is not liable, even though in principle there might have been a wrongful act. But now the other category that we raised as a justification is the state of necessity, which is a circumstance precluding wrongfulness. There, in the first place, there was a breach of an obligation of international investment law, for example, national treatment or FET, expropriation, etc. And the implication of invoking this state of necessity is to suspend, not terminate, liability. The ICJ has provided the conditions in its decision or judgment in the Gapsikovo-Nagimaros project case, and it has indicated that the conditions include: one, that at stake must be an essential interest of the state; two, that interest must have been threatened by grave and imminent peril; three, the act being challenged must have been the only means, and this is very important in the midst of the COVID-19 crisis; four, that act must not have seriously impaired an essential interest of the state towards which the obligation existed. 5, the state author of that act must not have contributed to the occurrence of the state of necessity. And this, again, is very important for purposes of the COVID-19 crisis. If we look into specific measures, we can outline 3. And these are examples. 1 would be the host state suspends for 3 months the obligation of economically deprived households to pay water utility bills in order to secure access to water and promote hand washing habits. There might be a number of breaches. The second measure would be the state uses the powers to issue compulsory licenses, allowing others than the patent holder to produce and supply drugs to treat COVID-19. The potential breach there would be expropriation. And 3, issuing economic packages for local businesses owned by domestic investors affected by the crisis. There could be a breach of national treatment if domestic investors are given those packages and the foreign investors are not. So how to address those measures in light of the justifications that were raised at the beginning. Before going too far, it is important to stress that in any analysis, you will have to look, or a tribunal will have to look into the characteristics of the state measures, the circumstances of the health crisis in that particular state, and this would be a key element of importance, is the circumstances of that particular state, whether and what the degree of readiness of that country is. Did the state have a robust healthcare and hospital system or not? The answers may be different if we take, for instance, a country in the Nordic countries to a country in Latin America. Now, going into how to analyze those measures. For measure 1, where the suspension of the obligation to pay utility bills was imposed, it appears that in principle such measure would be fairly basic and effective to stop the spread of the virus, considering that the spread can be stopped with water and soap. For instance, in that particular case, one can look into the DR-CAFTA, Article 21.2, and the reference to an essential security exception. As to measure 2, where the state uses its power to issue compulsory licenses, in addition to the state of necessity and necessary measures, provisions that we already outlined, it is important to note that many new generation of treaties like the CETA have specific exceptions within the expropriation provisions that provide that as long as there is conformity with the chapter of intellectual property and the WTO TRIPS agreement, the compulsory licenses may not be interpreted as expropriatory. And that article is 9.85 of the CETA. Finally, as to measure 3, which includes economic packages for businesses in the host state and differentiating between national and foreign investors, though in principle there might be discrimination, it is important to note that the test for national treatment violation includes the possibility of justifying the differentiation with rational based policies. So with that, I will simply move to a last point as to where would we be taken in 5 years, and whether the system should declare a moratorium on the investor-state arbitration system. One thought that I would like to leave you with is that this system, the investor-state arbitration system, appears to have sufficient legal escape valves and provisions to be invoked by a responsible state that is confronting a crisis. Of course, there's provisions that they can use both of investment treaty arbitration treaties and of public international law. With that, thank you, and I turn the floor to my next co-panelist. Thank you.
Thank you very much, Jose Antonio, for that message. And now we go to Mallory. Mallory, Jose gave a detailed doctrinal discussion of what defenses under public international law states may have and under investment treaties. My question to you is, are there any other defenses that states may have in the current environment of the crisis? We have heard that our panelists were talking about policy space, etc., and maybe there are other defenses. We would appreciate if you could comment on those.
Thanks, Borzu. That's a great question. But before I answer, I want to join my co-panelists in thanking the ILI for inviting me. It is an honor and a pleasure to be here with all of you today. Now, turning to the defenses, let's just quickly see if my PowerPoint will work. Now, beyond what Jose Antonio was discussing earlier about the legal defenses, the actual express hooks for states in investment treaties, in free trade agreements, or under international law, there also are a series of additional objections or defenses that are pretty much based in fact. They're practical defenses. And if you go back and consider the claims that Ian and Jennifer were discussing earlier, each of them has their own different factors that are considered, but they basically have 4 elements to them. There is a duty or obligation that was breached by the respondent state, causing injury to the foreign investor, which would be the claimant in a given case. And each of these individual elements could serve as the basis for a defense for the state. The state could argue, for example, that there was no duty because the investment treaty didn't apply or because the particular obligation didn't apply to situations of strife. The state could argue that there is no injury to the claimant that is attempting to bring the claim, and that because of that, what the claimant essentially is asking for is an assessment in the abstract over whether a particular government initiative or measure was fair, equitable, non-arbitrary, non-discriminatory, etc. The state could argue that it didn't cause the particular injury, or that the entity or person who did cause the injury isn't a person or entity whose conduct is attributable to the state under international law. But what I anticipate being the main defense of many states is that there was no breach. Now, as I said, there are a lot of different factors that go into each individual claim. But in large part, one of the themes of a defense of a state is that the state acted reasonably. And this is a very, very fact-specific defense. So let me just give you an example of something that a state might argue. So governments are essentially people. And because of that, governments tend to tell the human side of the story when they're presenting their defenses. So a defense may sound something like this. This is Sally. Sally has submitted a witness statement in this arbitration, and she works at Agency X of the government. The COVID-19 pandemic created a highly unusual problem that she attempted to find a solution for. Now, she needed to act very quickly under conditions that weren't ideal. Her budget and resources were limited. She was dealing with countless unknowns, and her teammates, like so many people around the world, were confined to their houses and weren't set up to be working from home. It wasn't just that they lacked a monitor or a separate keyboard or separate mouse. It wasn't just that they suddenly needed to work and simultaneously homeschool their children. It was that they lacked the tools and infrastructure, because the rule for governments up until now was that for security reasons, all work needed to be done on site at the office. On top of that, external emails were limited to 10 megabytes. There was no way to affix a seal or a formal stamp to documents. People may not have even had printers, and there may have been laws that precluded electronic signatures. There were a lot of obstacles. And on top of that, there was no clear substantive path forward. So what did Sally and her agency do? They tried. Given what they knew at the time and the limitations that they faced, the measure that was adopted was reasonable. Was it perfect? No. How could it have been? These are humans who are attempting to solve a problem. Humans are imperfect and their solutions will be as well. And investment treaties don't require protection. This was a good faith attempt to solve a multidimensional problem. So I expect we'll see arguments like that, but they also may differ. That particular story isn't going to apply in every single investment treaty case and to every type of measure. But I would wager that what we'll see is human stories like this one. We also likely will see one of the basic facts of life, which is that the best laid plans go awry, and they often have unintended consequences. So some defenses likely will focus on that piece of the story as well. For example, again, Sally is in Ministry X, which isn't the health ministry, and Sally might need to say in a witness statement, well, the health ministry needed more people to review documents and to analyze data. So we seconded people to the health ministry to do this. But because of that, our resources were even more limited, and we weren't able to review all of the permit applications with the same expedients that we typically do, and so it took a lot longer than usual. Therefore, this was a reasonable delay and not an undue delay under international law. Now, again, the circumstances will change, but I expect to see many human stories. Now, in terms of what governments can do now, claims haven't really been started yet, but they likely will come very soon. And among the things that governments can do now to prepare themselves are three. First of all, make a record. Take note of the limitations you face, which you may forget in a week, in a year, or even longer. They may be legal limitations, practical, budgetary, social, physical, personal, technological, something else, or some combination of all of the above. But take note of them so that later on when there's a question about why or how something happened, you have notes. You can refresh your recollection. Second, plan for the inevitable glitches. Create a review process or maybe an appeals process or conduct periodic assessments to see if there's room for improvement or anything that needs to be adjusted. And if you are going to have changes, you need to, third, communicate those. If the situation is fluid, which it likely is, then say so. The same is true if a solution is temporary and you expect it to change. Make that clear, communicate it to your constituents in order to manage expectations. So again, investment treaty cases often tell a human story, especially on the side of the state. For investors as well, they are telling a basic human story about how they experienced the impact of the COVID-19 crisis. But it's important to communicate that piece of the story because ultimately that's what many reasonableness claims come down to. Thank you.
Thank you, Mallory, for that practical insight. It was very interesting, and thank you for keeping everyone the time. I'm getting a lot of questions from the participants. I intend to put the questions to the panel after we finish, so we'll see how many of them can be answered. Now, let's turn to Christina. And Christina, would you tell us about implications of these measures for assessment of damages? Damages is my favorite topic, but I mean, it's. I was wondering whether there are any discounts for assessment of damages. What principles would play here? Maybe causation and others. We appreciate your input on that. Thanks.
Thank you, Borsu. And I too would like to start by thanking the ILI for the kind invitation to join today's discussion, as well as to the audience for tuning in to today's talk in your busy schedules. As mentioned, I'll be covering the topic of causation. I'm going to ask Oregon to display my overview of topics, which is the next slide. Thank you. So as you can see on the slide displayed, I propose to cover three main topics. First, I will briefly set the scene by discussing the treatment of compensation and investment and international law. And next, I will cover two issues that I think are of relevance to today's theme, causation and valuation. So turning to the first topic. Under international law, a state is obligated to make reparations to the injured party for internationally wrongful acts. Reparation may take the form of restitution, satisfaction, or compensation. The object of reparation is, to quote the famous Chorsu factory case, to wipe out all the consequences of the illegal act and re-establish the situation which would, in all probability, have existed if that act had not been committed. Many BITs provide that a state must compensate a foreign investor for the expropriation of its investment. In practice, compensation is the most common form of relief requested in investment cases, regardless of the type of breach. So compensation claims are typically based on lost profits, lost future profits. The challenges of proving damages resulting from COVID-related claims will likely be amplified in proving causation and valuing losses. Let's start first with causation. Causation is a conceptual bridge between liability and damages. That is, a tribunal would have to first find a breach and determine that breach caused the claimant's losses before it could proceed to quantifying damages. Causation has both a factual and a legal element. For factual causation, the key issue is, but for the breach, did the state's wrongful conduct cause the investor's injuries? So that's the but for or the counterfactual scenario. The legal element, however, acts as a limit on factual causation. So here, the question is whether the causal link between the wrongful act and the injuries is sufficiently proximate to require compensation. In the context of COVID-related claims, there may be challenges in establishing causation. This respondent state might be able to argue that the business's failure was inevitable because of global pandemic, regardless of the disputed measures. That is, a state may be able to cast doubts on factual causation, as was the case in Bywater Gov versus Tanzania, albeit not involving a public health crisis. In a COVID-related case, however, the state might be able to show that losses were caused, for example, by a reduction or change in consumer demand, the inability of the investor to raise financing, which would have been needed in order to continue with the investment, rampant illness in the workforce, and we've seen it here in the US where large meat processing plants suffered a large amount of sick workers. And finally, disruptions of the global supply chain, and these are just to name a few examples. Now, there may be econometric tools, for example, regressions analysis, that can be used to isolate the impacts of other factors. In practice, however, tribunals have approached these somewhat less familiar methods with some skepticism. For example, in Ron Patrol versus Romania, the claimant's expert applied an event study method. Although the method is quite common in securities litigation, its use in investment arbitration is far less frequent. In this tribunal's view, this approach had failed to isolate the effects of the illegalities that had occurred in the course of an otherwise legitimate corruption investigation. But I'll leave it up to the economists to debate the viability of using statistical tools for this purpose. I'd like to now turn to valuation. Even in the best of conditions, valuation is no more than a best guess at the most probable outcome. The dynamic response of states to this novel virus intensifies the challenges associated with valuing an asset in a few ways. First, there may be issues associated with the valuation date. In many cases, the date of valuation will be set at the date of the breach. There may, however, be difficulties in establishing the date of the breach when the state adopts a series of measures to respond to the crisis. In addition, there may be some cases where the value of the investment is actually higher after the date of the breach. For example, we can think of the nationalization of a factory producing ventilators. Here, it's likely that the factory would command a higher value during the crisis. In those cases, the investor would likely argue for a valuation date at the date of the award. And we've seen a few cases that have gone in that direction. For example, ADC versus Hungary or Kiborex versus Bolivia. Second, parties will need to consider the valuation approach. For example, the rollout of a series of measures at different stages of the pandemic may also calculate the calculation of damages. It's possible that some measures may be seen to violate the state's obligations, but not others. The iterative legislative response adopted in Spain in the renewable energy sector provides a good example of this. It may be necessary, therefore, for investors to particularize the losses associated with short, medium, or long-term measures. In addition, there may be difficulties in calculating lost profits with reasonable certainty in the age of COVID. The most common approach for assessing lost profits is, of course, the discounted cash flow method. But the discounted cash flow method is built on a series of assumptions regarding cash flows and risks. The instability of the market may make it more difficult than usual to make projections, and we can talk about why that is in the Q&A. Despite these challenges, there may be certain strategies, however, that parties and tribunals could adopt that could improve certainty. Experts might value different scenarios. Alternatively, experts could provide tribunals with a model where they could adjust the assumptions. And this approach has become much more common in my experience. Finally, experts could update the damages calculations prior to the award. This would allow the tribunal to use the most current information. However, this approach should be limited to cases where the valuation date is the date of the award. Otherwise, it would offend the fair market value standard, which provides that only information available to the market at the valuation date should be taken into account. In the interest of time, I will end my remarks here and I'll pass the floor back to Borzu. Thank you.
Thank you very much, Christina, for your comments. And we have received a number of questions. And I'm going to essentially direct them to you. And if others want to comment, you're welcome to do that. In the time remaining, though, I don't know how many of them we can go through. The rest of them, we're gonna, once the video link is posted on the ILI website, that is www.ili.org, we will answer them there. And the first question, one of the question from Aman Kumar, and this is for Jennifer. And the question is, suppose there is a contract having national courts as a jurisdiction. Will the breach of such contracts attract the umbrella clause and would allow the investors to bring claim under the treaty? Jennifer, any thoughts?
Sure. I just want to say that I was briefly following people's questions and they were very interesting. So thank you all for putting forward such really interesting questions. And then unfortunately, this isn't super dynamic so because of the nature of it. But in any case, thank you for putting those forward. So in the context of an umbrella clause claim, the issue is the content of the umbrella clause, the language of the umbrella clause itself. But as a general matter, if there is an obligation that the government has entered into in a contract and commitment to the investor, then if there is a breach of that, that is a possibility of something that could be brought up under the umbrella clause. There's some controversy about exactly what point in time that would be the case, or how much of a breach or nature of the breach it would have to be. But the mere fact that a contract has a separate dispute settlement provision in it is not necessarily dispositive that it wouldn't be under the umbrella clause, because the umbrella clause is a treaty violation, something separate from whatever obligations there might be under the contract.
Thank you, Jennifer. I'll move to the next question unless the panel wants to provide more comment. There is another question which I'm going to direct it to Jose Antonio because I think it more relates to his subject matter. It's from Sophie Maya. It says, how do you think government actions such as, for example, Trump waiting until March when he already had access to information about COVID-19 in January will affect the state having, quote unquote, contributed to the occurrence of the state of necessity? If you have any comments on that.
Yes, thank you, Maya. This is not necessarily, it is a difficult question, but it's also a very sensitive question, given the status of the pandemic in the U.S. Without referring to the actual weighting of the U.S. government or the government's action or inaction, I would like to say this: certainly inaction or negligence would be taken into account if it were to contribute to increase the pandemic or the spread of a disease. That being said, in this particular crisis, what I see is that a lot of the information about the virus is one that we have been all learning on a daily basis, whether kids are vectors, whether a mask was sufficient. So the uncertainty of the disease and of the event certainly plays as a strong argument for any state to either characterize the disease or the pandemic as one without sufficient scientific certainty that the actions or inactions that it took might have been sufficient at the time that they were taken. It's very easy to do an analysis after the fact. In US speak, Monday quarterbacking, but it's very difficult to respond on a daily basis when things are not certain. And this is connected to whether the principle of precaution is being used. Something very similar seems to be happening in certainly developing countries where they don't have the luxury of waiting and trying to take focalized measures. They have to close the whole country to air traffic, or to take very severe measures in light of the circumstances. I will stop at that. Thank you for the question.
Thank you very much, Jose. Next question is for Cristina from Tiago Duarte Silva. It says, thanks for setting this up under an ex-ante approach to quantifying damages. What do you see as the role of being able to predict the depth and the expected duration of COVID-19's economic effects? You're on mute, Cristina.
Sorry, yes, I realize that. Thank you for the question, Dardo. So I do think the choice of valuation method will be driven largely by the availability and the quality of the data. And as I mentioned, market volatility will make it much more difficult than usual to make projections. For example, changes in consumer demands and commodity prices and higher production costs can impact the reliability of cash flows. And similarly, discount rates, which reflect market factors like risk-free rates, market risk premium, undiversifiable risk, and country risk, will continue to suffer from volatility over the coming months and possibly years. As a result, I think this affects the choice of methodology that tribunals may take comfort in applying. And the same market conditions could also affect the reliability of other methods, such as the comparables approach. So in light of this, tribunals may be more inclined to use some other method like the cost approach. This is a method that tribunals often resort to when lost profits can't be determined with the requisite degree of certainty. However, it's important to note that an investment's fair market value is not equivalent to the investor's sunk costs, which may either be higher or lower depending on the circumstances of the case. I hope that answers his question.
Thank you, Christina. We are over time, but there is a question for Ian Laird. Let me direct that to Ian. Ian, there is Mark Clausen has asked that to what extent reliance on the legitimate expectations by investors, especially these that are based on the specific representation of states, might be successful in future COVID-19 related investment cases. Would you comment on that, please?
I'll be very quick on that. As Mark has identified, legitimate expectations is a key element of the fair and equitable treatment standard, and certainly I think we'll see cases involving that standard. It's interesting though, in that application of legitimate expectations, not only is it the expectations of the investor in terms of representations made by them in making their investment, that is a context which also includes, and we've seen this in a number of cases, arbitrators recognizing that the government's situation plays some element of what is a reasonable expectation, and question that what would a reasonable expectation be during a international crisis of the size of COVID. And I think we'll see questions like that being addressed in future cases. And it really will be very, as Jennifer said, very fact dependent. And the circumstances of each situation will bear on how this question is answered in future cases.
Thank you, Ian. Last question, and I'm going to ask Mallory if you would answer that. This is a question from Anastasia Gebem. I hope I pronounced last name correctly. Forgive me if I didn't. Thank you to the panelists for good presentation. Since COVID-19 is novel and has resulted in far-reaching economic implications where many states are struggling to find a solution to address it, could this be a valid justification for non-performance of parties' obligations? Thank you.
Thank you for the question. I will try to go quickly and say it could be part of the answer. And we've seen this in previous cases. So many states in Europe attempted for the first time to create legislation that would promote and cover renewable energy sources, but no one had experience in it. They were trying something that was new. Here too, this is something that, if not unprecedented, hasn't happened since 1918. And people obviously will need a bit of leeway if they're dealing with something that is unexpected, unprecedented, and novel. But that alone won't necessarily justify what the state has done. For example, if the state were to use the coronavirus as an excuse to just kick out every foreign investor from its territory arbitrarily, you still need the additional explanation of this is what we were doing, here's why we were doing it, and there is some inherent logic to what we were doing based on the information we had and the resources that we had at the time. So it's part of the answer, but not necessarily the full answer.
Thank you very much, Mallory. Thank you. Thanks to all of the speakers for making this possible. Thanks to the attendees. I also thank Professor Don Wallace of the ILI and ILI staff, the invisible staff, Gorgin Karapetyan, our director of the IT, who has really put this whole thing together and trained us how to operate in a virtual environment, and Jeff Ziarnik, ILI program administrator, who has been really working diligently with Gorgin to make this happen. We will put the recording on ILI website, and which is www.ili.org. And we will answer the remaining questions on the website. We will distribute the link. A number of you have requested that the link to the program be distributed. I will coordinate with Gorgin to do that. We welcome any other comments that you have, and we hope to see you in the future. If you have any suggestions for future programs, please let us know. Thank you and goodbye.